She was genuinely hurt. I want you to hold on to that, because it matters to what I am about to tell you, and because the case makes no sense without it. She was genuinely hurt, and she had absolutely no case. Both of those things were true. Both of them were true at the same time. What do you do with that as a judge? What do you do when the pain in front of you is real, and the claim built around it has no legal foundation? What do you do when the person in that chair has come to your courtroom looking for something a courtroom was never built to give? I have been in that room, that specific seat behind that bench, long enough to recognize what I am looking at before the first word of testimony is spoken. My name is Marcus Reed. I spent 28 years on the circuit court bench in Fulton County, Georgia, and 11 years before that as a prosecutor in the same county. And what I saw walking into my courtroom that morning is something I have seen in other shapes many times before. The specific shape of a person who has decided that a judge can give them what their neighbor would not. If what gets said in these rooms is something you want to hear, subscribe, hit the bell. What I bring here requires someone to keep bringing it. And before we begin, what would you tell someone who is about to do what this plaintiff did? Someone standing at the courthouse door, complaint in hand, convinced that what they are about to file is justice. What do they need to know first? Write it in the comments. Because the question of what a courtroom can actually give you and what it cannot is exactly where this case begins. I want to tell you about the moment I read the complaint in this case, because the moment I read it is the only honest place to begin. I had it on my desk the evening before the proceeding. I had cleared through my afternoon docket, and my clerk had left the next morning's files in the usual stack. I worked through them in order: employment dispute, property boundary, breach of contract, and then I reached the last one. I read it once. I set it down. I picked it up and read it again, not because the language was complex, but because I wanted to be certain I had understood it correctly on the first pass. I had. A neighbor had filed suit against another neighbor for not being invited to a backyard barbecue. I want to be precise about what the complaint contained. It was not a brief document. It had been filed with care. Multiple pages, numbered paragraphs, an accounting of damages that included emotional distress, social harm, and what the plaintiff described as the deliberate and targeted infliction of humiliation. There was a section detailing the proximity of the homes. There was a section describing the plaintiff's awareness of the gathering, the sounds of it, the visibility of it from her property, the duration of it. There was a section establishing the relationship between these two neighbors and asserting that the failure to include the plaintiff constituted an intentional act designed to cause harm. I read all of it. I sat with it for a moment, and then I did the thing I have done at the end of every working day for 28 years on that bench. I set the file down and went home, but I thought about it that evening. I want to tell you why. Because the reason is not what you might expect. I was not thinking about the legal questions, which were, even at that early stage, not complicated. I was thinking about the plaintiff, about what a person has to believe, about themselves, about their neighbor, about what a courtroom is for, to file that document. Because the filing of it is itself a piece of evidence, not legal evidence, evidence about a person. And the person it described was already very clear to me before I had heard a single word of testimony. There is a particular kind of certainty I have watched walk into my courtroom more times than I can count. It is not the certainty of someone who knows the law is on their side. It is the certainty of someone who believes the room will rearrange itself to confirm what they already feel is true. They are not calculating odds. They are not weighing arguments. They are arriving with a verdict already written, and they are present only to collect it. I had seen this before. Not this person, but this certainty, the specific, unexamined certainty of someone who had reached a point in their life where their feelings about a situation had become, in their own mind, the legal facts of it. What I did not know that evening, what I discovered the following morning in that courtroom, was the full shape of what had brought these two women into the same room over a backyard gathering on a Saturday afternoon in summer. The complaint had given me the plaintiff's version. What the proceeding gave me was something else entirely. The plaintiff arrived first. She was dressed with the care of someone who had thought about how she wanted to be seen, not by the defendant, not by the attorneys, but by me. She sat at the table on the plaintiff's side and arranged her documents in front of her, and then looked up at the bench with an expression I recognized immediately. It was the expression of someone who has already decided they are right and is now waiting for the authority in the room to confirm it. There was no anxiety in her. There was impatience. The impatience of someone who believes the formality that precedes the outcome is an inconvenience, not a process. The defendant arrived a few minutes later. She was quieter. She sat down without arranging anything. She looked at the table for a moment, and then she looked at the plaintiff, and then she looked straight ahead. She had the expression of someone who still could not entirely believe she was there. I understood that expression, because here is what I had not seen in the complaint, and what became clear in the first minutes of that morning. The defendant was a woman who had hosted a barbecue in her own backyard, invited the people she wanted to invite, and had not invited the woman sitting across from her. And she was now required to explain that decision under oath to a judge, in a proceeding that had cost her time and money, and the particular exhaustion of having to treat something unreasonable as though it deserved a serious response. That is where this case began, not with the barbecue, with the decision that the absence of an invitation was something a court should address. I have been asked since this case closed whether I was surprised by it. The honest answer is, not by the case itself. What surprised me, and I use that word carefully because very little surprises me after 28 years, was the specificity of what the plaintiff believed. Not just that she had a grievance. People bring grievances into courtrooms. That is what courtrooms are for. What surprised me was the shape of the belief underneath the grievance, the genuine conviction that her feelings about the invitation were a legal injury, that her neighbor's choice was a legal wrong, and that I was the appropriate person to correct it. She testified first. I asked her to explain in her own words what she believed had happened and what she believed she was owed. I gave her the full space to do that. I did not interrupt. I did not indicate by expression or posture what I was thinking. That is part of the job. You give a person the room to make their case, fully, before you begin the work of examining it. She spoke for a considerable time. She described the neighborhood, the duration of her residence there, the relationship as she understood it with the defendant. She described the day of the barbecue, the sounds, the smell of the grill, the cars she recognized parked in front of her neighbor's home. She described what she felt. And I want to be precise here because what she described is a real thing. The feeling of being excluded is real. The sting of it is real. Watching a gathering happen from which you have been deliberately omitted is a genuinely unpleasant experience, and I am not going to stand in front of you and tell you it isn't. But then I asked her a question. I asked her whether she believed her neighbor was legally required to invite her. She paused. It was a particular kind of pause. Not the pause of someone searching for the answer, but the pause of someone deciding how to frame an answer they believed they already had. And then she said, I believe that what she did was wrong, and that wrong actions have consequences. I noted that answer for the record, and then I asked the question again, more precisely. Not whether she believed the action was wrong, whether she believed her neighbor had a legal obligation to include her in a private social gathering on private property. She said, I believe a judge can decide that. I want to stay with that answer for a moment, because in 28 years, I have heard a great many things said to me from that chair, and that sentence, I believe a judge can decide that, is one of the most revealing I have encountered. Not because it was wrong exactly. Judges do decide things. But the particular confidence with which she said it, the specific belief embedded in it, told me everything I needed to know about what she had come to this room expecting. She did not believe she was asking me to find a legal remedy. She believed she was asking me to confirm a verdict she had already reached. She believed this proceeding was a formality between her grievance and its validation. That belief was about to meet the record. The defendant testified after the plaintiff. She was calm, not the calm of someone who does not care, but the calm of someone who had decided that the only thing available to her in this room was the truth, told plainly, and that the truth told plainly would be sufficient. She explained the relationship between herself and the plaintiff from her perspective. And what emerged in that testimony was a history that the complaint had not contained. Over the course of the preceding months, the plaintiff had made a series of demands on her neighbor that I will describe as consistent with a person who believed proximity entitled her to inclusion. She had arrived at the defendant's door uninvited on multiple occasions. She had offered opinions on the defendant's property, her visitors, her schedule. She had expressed displeasure, directly, on more than one occasion. when the defendant had made plans that did not include her. She had, in one instance the defendant described in detail, informed the defendant that as her neighbor, she deserved to be considered. That was the word she had used, deserved. When the defendant finished her testimony, I looked at the plaintiff. I asked the plaintiff whether she disputed any of the specific incidents the defendant had described. She said, "I don't believe those things are relevant to why we're here." That sentence. I want you to hold that sentence, because it is the fullest possible expression of the belief that had brought this case into my courtroom. The history between these two people, the actual documented texture of the relationship, was, in the plaintiff's view, not relevant. What was relevant was the barbecue, the specific exclusion, the moment she was left out. Everything that had produced that moment, everything that explained it, everything that gave the defendant's decision its full human context, none of it was relevant, because none of it was about her grievance. I have thought about that answer many times since. Not because it was unusual. I have heard versions of it before, from people who have arrived in courtrooms with a conclusion and no interest in the evidence that complicates it. What I have thought about is how complete it was, how perfectly it expressed the structure of the belief underneath this case. The plaintiff did not want the full picture examined. She wanted the single frame, the barbecue, the exclusion, the feeling, validated and answered. She had arranged her understanding of events so that the context was always beside the point and the injury was always the center. And she had come to my courtroom believing I would accept that arrangement. I did not. There is a version of justice that the plaintiff in this case was looking for. I want to name it honestly because I think it is important to name it, and because I think you know what it is. She wanted someone with authority, someone whose authority could not be disputed, to tell her that she was right. Not right in the legal sense, right in the sense that matters to a person who has organized an entire grievance around the question of whether they deserve to be included. She wanted the validation that the invitation had not provided. She wanted me to look at her neighbor and say, "You should have invited her. You were wrong not to. She deserved a place at that table." That is what she came for. And I want to be direct with you about something. I understood it. Not the lawsuit. The lawsuit I will address in a moment. But the wanting, the specific human desire to have someone in a position of authority confirm that you were worth including, that you were not someone who could be set aside without consequence, that your exclusion meant something and would be treated as something. I have been a judge for 28 years, and before that a prosecutor for 11. And in all of those years I have watched people come into rooms looking for what this plaintiff was looking for. Not always through a lawsuit, not always over a barbecue, but looking for the same thing, the recognition, the acknowledgement, the confirmation that they exist and that their existence has weight. I understand that desire. I cannot give it from a bench. What I can give from a bench, the only thing I can give from a bench, is a ruling on what the law addresses. And the law does not address whether your neighbor was obligated to invite you to a gathering on her private property. It does not address whether her decision to exclude you was unkind. It does not address whether you deserved better from someone who lives 40 feet from your front door. Those are real questions. They are human questions. Some of them have real answers. None of those answers are mine to give. I ruled in favor of the defendant. I want to tell you exactly how I said it because the words mattered to me, and I chose them carefully. I said, "The law does not require a private individual to include any other person in a social gathering held on private property." The plaintiff has presented no cognizable legal claim. The defendant exercised a right that belongs to every person in this country, the right to choose who enters her home and who does not. That right does not diminish based on proximity. It does not diminish based on the feelings of the person excluded. It does not diminish because the excluded person can hear the gathering from her property. The defendant's decision was legal. The plaintiff's claim is dismissed. That was the ruling. I delivered it without apology and without softening because neither was warranted. I watched the plaintiff hear it. I watched the specific moment when the room did not do what she had believed it would do, when the authority she had come to collect turned out to be something she could not take home with her. It was not a dramatic moment. From the outside, it probably looked like the ordinary conclusion of a brief proceeding on a Tuesday morning. From where I was sitting, it was the entire case. What she did not expect was not the outcome. I think some part of her, the part that had read enough to file a lawsuit, knew the legal ground was uncertain. What she did not expect was the absence, in my voice, in my posture, in the delivery of that ruling, of any indication that her feelings about the situation had changed what the law required. She had believed, I think, that the sincerity of her grievance would register, that I would hear how much this had hurt her and allow that to carry some weight, that the emotional reality of her experience would soften the legal reality of the case. It did not. It could not. And I want to be clear that this is not a failure of the law. It is the law doing exactly what it is designed to do. The law is not a mechanism for resolving hurt feelings. It is a mechanism for resolving questions that the law addresses. When you bring a question the law does not address into a courtroom, the courtroom cannot manufacture an answer for it. The courtroom can only tell you that the question is yours to carry out with you, unanswered, and to find your answer somewhere the law does not reach. I have thought about the plaintiff in this case since the proceeding closed. Not with contempt. I want to be honest about that. What I felt, sitting on that bench watching her hear that ruling, was something closer to the feeling I described earlier, the disappointed teacher. Because the desire underneath the lawsuit was recognizable to me. It was a human desire. The desire to matter, the desire to be chosen, the desire to have someone with authority say out loud that your exclusion was wrong, and that the person who excluded you owed you something. That desire did not belong in my courtroom. But it belongs somewhere. And the most honest thing I can tell you is that the place it belongs is not a proceeding, it is a conversation. It is the kind of reckoning a person has with themselves about what they actually need from the people around them, and whether the way they have been pursuing it is working. This plaintiff had decided that a lawsuit was the vehicle for that reckoning. She discovered in my courtroom that it was not. I have been thinking since I started doing this, since I started narrating these cases for you, from the seat where I sat when they happened, about what it means to want justice. Specifically, not justice in the abstract, not the concept of it. The specific desire to walk into a room where someone has the authority to say, "You were wronged, and the wrong will be answered." That desire is real. It is one of the most human things there is. It is what brings people into courtrooms. It is what builds institutions. It is what my father understood, a man who drove a mail route for 31 years and believed, with full knowledge of everything that worked against that belief, that the law was the most powerful tool available to ordinary people. He knew that the desire for justice was real and right and worth organizing a life around. But what I watched in that case, and what I have watched in cases like it, across 28 years of the same bench, is what happens when the desire for justice becomes detached from any particular wrong. When the wanting becomes its own object. When a person has decided that the feeling of being wronged is sufficient justification for anything they do in response to it, including filing a lawsuit over a barbecue. The want had become so large, so consuming, that it could not distinguish between situations it applied to and situations it didn't. And a courtroom cannot fix that. Only the person carrying that want can fix it. The dream she brought into that room. The dream of being told she had been wronged, officially, by someone whose job it was to know, could not be given to her. Not because the court was indifferent to her, but because the court exists to address legal injuries, and what she had experienced was not one. The release she needed was not a ruling in her favor. It was the release of the dream itself, the setting down of the belief that a judge could give her what the invitation had withheld. I could not do that for her. That is work that happens somewhere else, in a room without a bench. Here is what I want you to sit with. There is a difference between the desire for justice and the desire to be right. They feel identical from the inside, I know that. But from where I was sitting, they look completely different. The desire for justice connects to a specific wrong done to a real person. It has a shape. It has evidence. It has a claim the law can answer. The desire to be right is formless. It expands to fill whatever container you put it in. It can fill a lawsuit over a backyard gathering and call itself justice. And here is the harder thing I want you to sit with. Most of us have felt both. Most of us have, at some point, been in that plaintiff's position. Not necessarily in a courtroom, but in the general experience of wanting someone with authority to confirm that we were right, and the person who excluded us, overlooked us, undervalued us, was wrong. I have felt it. The difference is not that some people feel it and some people don't. The difference is what you do with it, and whether what you do with it is proportionate to what actually happened. This plaintiff had let it become a lawsuit. I dismissed it. And I want you to know that the dismissal for me was not a small thing. Not because the case was difficult, it wasn't. Because behind the complaint was a person who had chosen this out of all the choices available to her. And the choosing said something about what she believed about herself and about what she was owed that I found genuinely sad. I don't often use that word from this position, but it applies here. Genuinely sad. That is the desire I want to name for you, not the plaintiff's, but yours and mine. The desire to want justice the right way. The desire to be able to tell the difference when something happens to you between a wound that the law can address and a wound that requires something else entirely. Between a wrong that belongs in a courtroom and a pain that belongs in a conversation, in a therapy session, in a long walk, in a hard look at what you actually need from the people in your life. That discernment, knowing what kind of answer you are actually looking for, is one of the most important things I have watched people get wrong across 39 years in these rooms. The plaintiff in this case got it wrong, not because her pain wasn't real, because she brought it to a room that was not built to hold it. I want to know something from you. I want you to think about whether you have ever been in a version of that plaintiff's position. Not in a courtroom necessarily, but in the general experience of wanting someone with authority to confirm that you deserved more than you got. And I want to know whether you found what you were looking for, and where you found it, and whether it was where you expected it to be. Write it in the comments. I read every one of them. Not because I can answer them the way a bench can answer a legal question, but because the record of what people are actually carrying deserves witnesses. And I have been a witness in rooms like that for a very long time. If what you heard today felt true in a way you needed it to, if something in this case named a thing you have seen or felt and couldn't quite put into words, I would be glad to have you here. Subscribe, hit the bell. I don't bring opinions to this channel, and I don't bring performance. What I bring is the same thing I brought to that bench for 28 years, the account of what I saw, from the one seat in the room that was required to decide. That is what this channel is. That is what it will remain. This case is closed. The neighbor went home, the defendant went home, the complaint was dismissed. And somewhere in that plaintiff's life, I genuinely hope, she found the room she was actually looking for. The one where the answer to the question she was really asking was available to her. It was not my room, but I believe it exists. And I believe she deserved to find it. That is the thing she came to my courtroom for. And the most honest thing I can tell you is that it was available to her all along, just not from a bench.